Yesterday, I watched a YouTube episode of the Akash Singh show, more than 2 hours in duration, featuring Kushal Mehra. And the title of the video was India's Constitution Sucks. Very provocative title. It really got me curious, so I watched it. And within the first 5 minutes, I realized that it was not meant to disparage anything about India. It was from the point of view of somebody who wants things to improve in India, and it was delivered by people living in India. So, whenever somebody talks about India and they are not living in India, I stop taking them seriously. Okay, even if you're living 6 months outside India, if you're spending 6 months in India, I still have time to listen to what you have to say. The overarching theme of that episode was the First Amendment in the United States of America is the greatest thing ever, especially from the point of view of stand up comedians. So, in this video, I'm going to talk about the First Amendment of the United States of America. It is often perceived by Indians as this blanket right to free speech without any restrictions. That is not the case. So, also going to talk about some landmark court judgments which did limit free speech even in the United States of America. So, without further ado, let's talk about the First Amendment of the United States Constitution. Let's first talk about the text of the First Amendment of the United States Constitution. It states, and I quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. But this freedom of speech, even in the United States of America, is not absolute. It perhaps is the most free country when it comes to freedom of expression, the United States of America, no questions there. But even in the United States of America, there are restrictions to what constitutes freedom of speech. I found on the United States Court's website, a website dedicated for educational purposes only, that there are 6 things which are not included as a right in the freedom of speech provisions. So, freedom of speech does not include as a right, number one, to incite imminent lawless action. Number two, to make or distribute obscene materials. Number three, to burn draft cards as a form of anti war protest. Number four, to permit students to print articles in a school newspaper over the objections of the school administration, of students to make an obscene speech at a school sponsored event, and of students to advocate illegal drug use at a school sponsored event. A very interesting thing here is 3 of the 6 provisions are talking about activities related to students. 50% of them talk explicitly about what students can and cannot do. Quite interesting there. Each of these 6 provisions are a result of court cases and sometimes landmark judgments by the Supreme Court of the United States of America. So let's talk about those cases which, in some cases, defined and in some other cases, redefined what constitutes freedom of speech in the United States of America. Let's find out what is banned speech in America, what the First Amendment forbids. Can someone stand at a rally and call for violence and still be protected by free speech laws in the United States of America? In 1969, the United States of America's Supreme Court said yes, but with a catch. This is the powerful and controversial story of Brandenburg v. Ohio, the case that redefined the limits of the First Amendment. In rural Ohio, a local Klan leader named Clarence Brandenburg invited a television news crew to film a KKK rally, Ku Klux Klan. The video showed men in robes burning crosses and delivering hate filled speeches. Brandenburg said things like, "It's possible that there might have to be some revengeance taken." He was arrested under Ohio's criminal syndicalism law, which banned the advocacy of violence to bring political change. Brandenburg appealed his conviction, claiming that his First Amendment rights had been violated. The case went all the way to the United States Supreme Court. The big question was, can the government punish someone for advocating violence even if no violence actually happens? In a unanimous ruling, the court overturned Brandenburg's conviction. Here's what the court said: the government can only restrict speech that is, number one, intended to incite imminent lawless action, and number two, likely to produce such action. This became known as the Brandenburg test. It's not enough to say something violent or extreme. Your words must call for immediate illegal action, and that action must be likely to actually happen. Let's look at it with an example. Saying we should revolt one day is protected speech. Saying let's burn down that city hall right now is not protected speech. Brandenburg v. Ohio replaced older, more vague standards like those from Whitney v. California. It gave stronger protection to controversial political speech, even if it is hateful, shocking, or offensive. It is why white supremacists, anarchists, and even radical activists can legally express their views as long as they don't incite immediate illegal acts in the United States of America. In essence, it set a very high bar for when speech becomes a crime. So here is the tough question: should speech that promotes hate or violence ever be protected as long as it is not calling for immediate action? The Supreme Court of the United States of America said yes in Brandenburg v. Ohio, because in a free society, even disturbing speech has a right to exist unless it becomes a direct, dangerous call to arms. Let's look at Roth v. United States. Can the government ban erotic books and magazines, or is that protected by free speech also? In 1957, the Supreme Court tackled that exact question, and what they decided shocked many. This is the story of Roth v. United States, the case that set the first legal definition of obscenity. Meet Samuel Roth, a New York businessman who ran a mail order publishing company. He sold adult literature and nude photographs through the mail. But federal law at the time said it was illegal to mail obscene materials. Roth was arrested, convicted, and sent to prison. He appealed all the way to the Supreme Court of the United States of America, saying, "My work may be sexual, but it is still speech, and the First Amendment protects that." The Supreme Court of the United States of America had to decide, does the First Amendment protect obscene content, or can the government legally ban it, even if people want to read it? In a 6-3 decision, the court upheld Roth's conviction and ruled that obscenity is not protected by the First Amendment. Justice William Brennan wrote that obscene material is utterly without redeeming social importance. So the First Amendment protects speech, but not all speech. The court also created the first modern definition of obscenity, now known as the Roth test. It asked, would the average person applying contemporary community standards find that the material appeals to prurient interest? Prurient means sexual. This made obscenity a matter of community judgment, not individual taste. Roth v. US was the first major ruling where the court drew a line between protected speech and criminal obscenity. It allowed the government to censor sexual material as long as it met that community standard of being too much. But there was a problem. What is obscene in New York might be normal in San Francisco. The Roth test was vague, and courts across the country were inconsistent. Eventually, in 1973, the court replaced it with the more specific Miller test in Miller v. California, which added clearer guidelines. So here's the bottom line. Roth v. United States was the case that said not all speech is free. It created the first definition of obscenity and gave the government power to decide what is too dirty for public consumption. But it also opened the door to decades of censorship debates, court battles, and controversy. What do you think? Should sexually explicit content ever be banned, or should all speech be free, no matter what? Let us know in the comments below. Now, should your town decide what you can watch, read, or mail to someone? In 1973, the US Supreme Court said, yes, this is Miller v. California, the case that created America's legal definition of obscenity. Marvin Miller owned a business that sold sexually explicit material, just like Samuel Roth. One day he mailed out graphic brochures, unsolicited, to random homes and businesses in California. One recipient was a restaurant manager who was not amused. He called the police and Miller was charged under California's obscenity laws. Miller appealed, saying this is protected speech under the First Amendment. The Supreme Court had to answer a big question. Is distributing obscene material protected by the Constitution? And how should we define what counts as obscene in the first place? In a 5-4 decision, the court upheld Miller's conviction but introduced a brand new test to determine what counts as legally obscene. Say hello to the Miller test. To decide if something is obscene and not protected by the First Amendment, it must meet all three of these criteria. Number 1. The average person using contemporary community standards would find the work appeals to prurient interests. Number 2. The work depicts or describes sexual conduct in a way that is patently offensive, as defined by state law. Number 3. The work, taken as a whole, lacks serious literary, artistic, political, or scientific value, also called the lapse test. Fail all three, it is obscenity and not protected. Pass any one, it is protected speech. The Miller test gave local communities the power to decide what is too offensive for them. So, what is legal in Los Angeles could be banned in rural Alabama. That means books, films, and even internet content can be judged based on local moral standards. Before this, the court used the Roth test from 1957, which was vague and led to inconsistent rulings. Miller v. California replaced it with something stricter, clearer, and more enforceable, and it is still the standard used today in the United States of America. So, should your community decide what is too obscene, or should free speech mean free for all? Miller v. California said obscenity is not protected, but defining it, that is up to the community. What do you think? Should the government have a say in what we read or watch? Drop your opinion in the comments. What is more powerful than words? A symbol, but when someone burns a flag or a draft card, is it speech or is it a crime? Today we are diving into two explosive Supreme Court cases, United States v. O'Brien and Texas v. Johnson. One protester went to jail, the other walked free. Why? In 1965, David O'Brien stood outside a Boston courthouse and burned his draft card to protest the Vietnam War. He was arrested under a federal law that made it a crime to destroy or mutilate a draft card. Fast forward to 1984. 19 years later, Gregory Lee Johnson burned an American flag during a protest at the Republican National Convention in Texas. He too was arrested, this time for violating a state law against flag desecration. In O'Brien's case, the Supreme Court ruled against him. In 1968, they said the government isn't punishing his message but protecting the draft system, a vital function. This gave birth to the O'Brien test, which lets the government restrict symbolic conduct if, number 1, it is within their power, number 2, it serves an important interest, number 3, it is not about silencing speech, and number 4, it is narrowly tailored. Since all boxes were checked, the court upheld the law. In Johnson's case, in 1989, the court ruled in favor of Johnson. Why? Because burning the flag, as offensive as it might be, is still political speech. They said the government cannot ban speech just because it is unpopular or offensive. Texas's law was struck down for being content based. It punished the act because of the message behind it. Let's break it down side by side. In O'Brien's case, the object burned was a draft card. In Johnson's case, it was the American flag. In O'Brien's case, the law was a federal law. In Johnson's case, it was a state law. In O'Brien's case, the reasoning was law protected government function. In O'Brien's case, it was the draft. But in Johnson's case, law targeted symbolic expression. So, ruling in O'Brien's case was against protester, and in Johnson's case, it was in favor of protester. O'Brien's speech was not protected, Johnson's speech was protected. So, in America, you can burn the American flag, but you can't burn the draft card. Free speech doesn't mean you can do anything, but it does mean the government cannot punish you just because your message is unpopular. What do you think? Was the court right in both cases? Let us know in the comments. What happens when students try to speak their minds, but the school says no? In 1988, the US Supreme Court ruled that schools can censor student newspapers. The case Hazelwood versus Kuhlmeier. Let's break down what happened and what it means for student free speech today. In 1983, students of Hazelwood East High School in Missouri were producing the final issue of The Spectrum, their school newspaper. As part of their journalism class, they wrote articles about teen pregnancy and divorce, topics they thought mattered. But when the school principal saw the draft, he pulled the two articles before publication. His reasons: privacy concerns for the students interviewed and fear that the content was inappropriate for younger readers. The student journalists were furious. They argued that their First Amendment rights had been violated, so they went to court. The case reached the Supreme Court in 1988. The central question: can a school censor student work if it's part of a class or school sponsored activity? The court ruled 5-3 in favor of the school district. Writing for the majority, Justice Byron White said, educators do not offend the First Amendment by exercising editorial control over student speech in school sponsored expressive activities, so long as their actions are reasonably related to legitimate pedagogical concerns. In plain English, if the activity is school sponsored, the school can set limits as long as it is for a valid educational reason. The court drew a sharp line between independent student speech, like a protest outside school, and school sponsored speech, like a newspaper written as part of a class. That means schools can edit or remove content from newspapers, plays, or assemblies tied to the curriculum, but they cannot punish students for expressing opinions on their own time unless it causes disruption. This ruling scaled back student free speech protections that had been set by Tinker v. Des Moines, which famously said students don't shed their constitutional rights at the schoolhouse gate. But Hazelwood added a major condition: not all speech is equal, especially if it is school sponsored. So, next time you're working on a school project and wonder how far your freedom goes, remember Hazelwood, especially if your school is in the United States of America. It is a case that still shapes student journalism and speech in classrooms across America. What do you think? Should schools be able to censor student newspapers, or should students have full editorial freedom? Three landmark Supreme Court cases draw the line regarding how much freedom of speech students have in school. And sometimes that line gets blurry. From political protest to school newspapers to inappropriate speeches, let's see what you can say and where schools can say, no, you can't say it. First up, Tinker v. Des Moines, 1969. A group of students wore black armbands to school to protest the Vietnam War. Peaceful, silent, symbolic. But the school suspended them. The students sued, and the Supreme Court sided with the students. Why? Because their protest did not disrupt class. This case set the substantial disruption test. Students don't shed their constitutional rights at the schoolhouse gate. If your speech is peaceful and does not interrupt learning, it is protected. Free speech wins. Fast forward to 1988. In Hazelwood v. Kuhlmeier, students wrote articles about teen pregnancy and divorce for their school newspaper. But the principal pulled the stories before print, saying they were inappropriate and too personal. The Supreme Court ruled in favor of the school. Why? Because the newspaper was a school-sponsored activity, part of a journalism class. That gave the school the right to control content. Hazelwood introduced a new standard. Schools can regulate speech that is part of the curriculum if they have valid educational reasons. Free speech was limited. Now let's go to 1986. Bethel v. Fraser. A student gave a speech full of sexual innuendos during a school assembly. It was technically about a student election, but the jokes way over the line. The Supreme Court ruled nope, schools can punish speech that is lewd or vulgar even if it is not disruptive. Schools have a duty to teach civil discourse and good manners. So even though it wasn't school sponsored like in Hazelwood and not peaceful like Tinker, the speech was just inappropriate. Free speech was denied. So what is the lesson? Student free speech exists, but it depends on the time, place, and tone. Speech is power, but in school, that power comes with boundaries. Want to wear a protest pin? Probably fine. Want to drop F bombs in a student election speech? Not so much. What do you think? Should schools have this much control, or should student voices be fully free? Drop your thoughts in the comments. Now look at this situation. A student holds a sign that says Bong hits for Jesus, gets suspended, and takes his case all the way to the United States Supreme Court. What happened next redefined student free speech forever. Welcome to the wild story of Morse v. Frederick 2007, where teenage rebellion meets constitutional law. In 2002, Joseph Frederick, a high school senior in Alaska, decided to make a statement. As the Olympic torch relay passed his school, he unfurled a 14-foot banner that read, Bong hits for Jesus. What did it mean? He said it was a joke, a random nonsensical phrase meant to provoke. But school principal Deborah Morse did not find it funny. She saw it as promoting illegal drug use. She tore the banner down and suspended Frederick for 10 days. Frederick sued the school, claiming his First Amendment right to free speech had been violated. After all, he was off campus and the sign did not cause a disruption. The case worked its way through the courts, finally landing at the US Supreme Court in 2007. The question: can public schools ban student speech that appears to promote illegal drugs even if it is a joke and even if it is off campus but school supervised? The court ruled 5-4 in favor of the school. Chief Justice John Roberts wrote, schools may take steps to safeguard those entrusted to their care from speech that can reasonably be regarded as encouraging illegal drug use. So even though the message was not disruptive or school sponsored, it went against the school's mission to discourage drug use. This case set a major precedent. Students still have free speech rights, but schools can restrict speech that contradicts their core educational goals, like fighting drugs. So in Tinker v. Moines, students wore armbands, free speech was protected. In Morse v. Frederick, students joked about drugs, speech was restricted. And that line between protest and promotion, it's not always clear. So next time you think about making a bold statement at school, think about what the Supreme Court might say. Bong hits for Jesus was meant as a joke, but it made history. I hope you liked this video.